we've done here, I know everybody understands how, we've all been impacted in all areas of the real estate, real challenges here, whether it's listing or buyer agents, whatever. So we decided to put this, give this a shot for Zoom and go over some of the questions I've been handling through emails and phone calls. So let's take a stab at this. First of all, I want you to understand real estate is not listed as an essential business. I keep hearing it's an essential business, but if you check what the governor put out, it's not. We're a professional business. As much as we think we are essential, we're more under you have to follow the workplace guidelines established by the federal and the state, which includes 10-person maximum. That's why we had to close the offices down. Sanitizing, mask, gloves, all that is in effect. So the first question I got was, should we continue to hold open houses? And I personally strongly urge agents not to hold physical open houses unless you are prepared to follow the guidelines. No more than 10 people in a property at one time. They'd have to do the 6 feet spacing. I think you'd have to have sanitizing hand gel there, masks, gloves, that type of stuff. So I'm more thinking and leaning, and so is NAR and NVAR, that we should be doing virtual open houses. Many different ways of doing that. The flip of that was buyers buying homes virtually. So if we're going to be doing this all by video, the buyer never sets foot in the property. How do you protect yourself? I recommend that you include a clause in your contract, something along the lines of buyer acknowledges that the buyer is responsible for personal verification, walkthroughs, and professional inspections to confirm the condition that the property is satisfactory. Because if they're never in there, they're always going to find something wrong. They find stuff wrong when they've seen the property. So I would advise that you protect yourself when it comes to that. Another question that I got, my seller wants to stop in-person showings. What should we do? I mean, they're afraid, they don't want people in their house, but they still want to sell their house. Well, seller has control over whether their property is shown and how it's going to be shown. What we have to be cognizant of is that the listing agreement says you're going to do certain things. So if they don't want you doing that now, I would draft up some kind of an addendum to the listing agreement showing the way they want you to now handle the showings. Or go to virtual showings and tours, Matterport or Facebook or Zoom, whatever you need to do. If they want to stop marketing, they just want to stop, rather than canceling the listing, I would probably go into temporarily off the market. So use the temporarily off the market. That keeps your listing active with you until they're ready to go back on, and at the same time get the listing extended. And you guys can ask questions as we go through. That's the reason I didn't mute everybody. This is not where I'm going to sit here and just talk the whole time. Okay. So next one, can I limit in-person showings to pre-qualified buyers only? One of the other questions I had is, should we have a hold harmless where people come into the house, hold harmless that if they came down with a coronavirus, did it get it at that house? Would be kind of hard to prove where they picked it up because it doesn't show up. So I don't think a hold harmless would, is of any benefit, but if somebody wanted to do that, they could. So yeah, you can restrict these showings to pre-qualified buyers only. My big concern is if you're requiring one person to be pre-qualified, they all have to be pre-qualified for fair housing reasons. So, and they may have a hard time getting pre-qualified, getting a lender right now to pre-qualify them. I don't know if lenders are very, into it right now or not, but you could say pre-qualified only. I had that question, and I don't know why you couldn't. Another question I got, can an agent require an individual to complete a COVID-19 screening questionnaire before showing? Yes, if that's what the owner wants and that's their request. Actually, Johanna created one of those for the Tyson's office, but also follow then the current CDC recommendations for social distancing. No more than, no closer than 6 feet. Wash your hands with sanitizers. Maybe even use those covering your shoes with those booties, face coverings. An owner can request that to show their home. I mean, this is unusual circumstances. Johanna wanted me to mention when it comes to these, to the settlements. We're still doing settlements. Luis is still doing settlements, but it needs to be limited to only the people that have to sign. They shouldn't be bringing family, friends, or anybody else. It should be limited only to the people that will be signing the documents, and then they're going to probably have social spacing, maybe even people in different rooms. I know I've been watching, before I left up there, Louisa was doing settlements outside. So these are different times. So please limit it only to the people that will be signing. Another question I got, does the fact that someone had COVID-19, is that something that has to be disclosed to everybody else? And I don't think so. But in unprecedented times, I might get the seller's permission to disclose that someone in the property had been, had this virus, but it was, more than 2 weeks ago, et cetera. But it's not, to me, that's not a known material adverse factor about the physical structure of the property itself. So, but I'd rather err on the side of good judgment and get the owner's permission to disclose if you have that situation. Another one that I got, the tenant called and says, I've lost my job or reduced hours, and now I'm requesting that you reduce my rent. Can they request it? Well, certainly. Do you have to give it to them? No. But if you do, VAR, if you go to the VAR's website, I have them here, they've come up with 2 new forms. The Virginia Association of Realtors have come up with 2 new forms. One is the request for rent alteration. And the question I had was, can we require proof that they have lost their hours or lost their income? Yes, you can. Okay. And this form, rent alteration request form, covers that. They also have a lease addendum to reduce the rent to a certain amount of time. I'm not going to go into great detail on those forms, but you can get those from the Virginia Association of Realtors website. Any questions about any of that?
Larry, I'm sorry to interrupt you. I think Sully wanted to know something in reference to walkthroughs and home inspections.
Okay, I'm getting ready to go into that.
Oh, okay.
Okay. So the big question I got for all this, one of the big questions I got, my buyer just wants to void the contract because of COVID-19. Can they just void the contract? No, there's absolutely nothing in our contract that addresses an unforeseeable event. Okay, once they enter that contract, that's it. Now, in common law, we have something in common law that's called force majeure, which is impossibility to complete a contract would let somebody out of the contract. Now, anybody that entered one of these contracts prior to the pandemic being what it is today and the restrictions, they may be able to use that to get out. But now that everybody knows, if you enter into the contract without this addendum that we're going to take a look at from NVAR, I think you're pretty much held responsible for settling because, you know, you entered a contract knowing the risk. So we're going to take a look at the contract. I asked them to have everybody download the contract, or if you have a copy of it, there are certain sections of the contract that I want to go over as far as why you can't get out of the contract. And first one would be paragraph 4, which is settlement. Okay, it says you will settle on or before with mutual consent. So if you're going to have trouble getting to the table or getting recording, that would have to be adjusted. And that was the purpose of this new form that we have that we will look at, the COVID addendum form. Walk through paragraph 11. I've had some questions about this. Does the buyer's agent have to go with the buyer to the walkthrough? Well, if you look at paragraph 11, it says seller will provide broker, buyer, inspector representing buyers, representatives of lending institutions for appraisal purposes, reasonable access to the property to comply with this contract. Reasonable access. In these times, a seller might consider reasonable access with the mask and the gloves and all that. But it also, when it comes to walkthrough, it says buyer and or buyer's representative will have the right to make the walkthrough. So contractually, the buyer could go without an agent. Okay, so technically they could go without the buyer's agent, but our statute requires, under agency statute, would require that the buyer's agent be there or another agent from that company, in my opinion, and also our code of ethics. So a seller does not necessarily, according to the contract, the seller would have to allow the buyer in the property and the appraisers, but it's wide open when it says reasonable access. So yes, the buyer's agent or somebody from their company should still be taking these people for their walkthrough. Okay, and it has to be a licensed individual with that company. It can't be a third party. Did that answer that question, Johanna?
Yes, thank you, Larry.
Okay. The next paragraph, when it's that I want to talk about is paragraph 22, and that's possession of the property. It says, unless otherwise agreed to in writing, seller will give possession of the property at settlement, including delivery of keys, etc. One of the problems that was brought to me is that the seller does not want to move because of the buyers. They want to delay settlement until this is over before they have to move. Unless you're using this addendum for an impossibility clause, I think they need to get out. But how do you force them out? Then you're going to have to go to court to force them out. Default paragraph of the contract, paragraph 28. If the buyer, and listen to it, if the buyer fails to settle for any reason other than a default by the seller, buyer shall be in default, and at the option of the seller, the deposit is forfeited. So any reason, okay? If they fail to settle for any reason. Now, if they had entered into a contract before we had all these restrictions, then I think they could probably go back to the common law, force majeure and impossibility, and go to court and win a case, but you'd have to go to court. With the new addendum, there would not be a default if we didn't settle. And that's why I want to take a look at that. And paragraph 35, time is of the essence. VAR came out with an addendum form for COVID. NVAR came out with an addendum for COVID. I recommend that you use NVARs if you used NVAR contract because of this paragraph, okay? And that is time is of the essence. means that the dates and timeframes agreed to by the parties must be met. Failure to meet the stated dates or timeframes will result in waiver of contractual rights or will be a default under the terms of the contract. So what does that mean? It means at midnight on the day of settlement, you no longer have a contract unless everybody has agreed. Okay, and that's why NVAR's addendum is drafted differently than VAR. VAR's contract does not have time as of the essence. We'll get there sometime close to this date, and if we do, we're good. So you know, don't try to use VAR's forms within NVAR contract. There was a reason ours was drafted the way that it is. Okay. So, any questions about any of that? Any other questions you might have?
Hey, Larry, this is Neil. I have two questions, and these are exactly in reference to that. I have two clients. One is selling their condo. It was a cash deal, and everything was done, condo package and all that was said. And now this lady just sends an email with the release of contract saying, "Oh, my buyer is concerned about the consequences of COVID-19. We want to get out." And I told her that, "Hey, you cannot get out, and you know, in jeopardy." She goes, "No, my broker said we can get out." And so my thing is, how do I recover that? I mean, my seller says, "Hey, no." So how do I go after that EMD? Because she flat out said, "Hey, if you're not buying this condo, here's a release and here's your COVID-19 addendum that you signed." I mean, you meaning my seller.
Well, I agree with you, but they're going to have to get attorneys involved at this point. Was this contract entered into prior to restrictions for?
No, this contract was ratified on 3/19 or 3/26. 3/26.
Yeah. So I think that they entered it understanding the risk that was out there. So, but once again, we can't play attorney. But I agree with you that that does not give them a reason to get out. The addendum was not used, correct?
No, the addendum was used. The COVID-19 addendum was used.
Okay.
It was used.
It was used. Okay. So when settlement?
A settlement was supposed to happen on 4/15 with the rent back till 4/30.
Okay. So what was the impossibility that she could not settle?
That's exactly, I said, if you look at the COVID-19, the clause says impracticability, if I'm not mistaken, or something like that. Force majeure, I haven't told her that. I said, go do NVR resources. And she's saying that, "Oh, we want to get out." That's it. She has no reason. The only reason she gives is concern.
Okay. So, that's one of the things it does say is that it's not that you're afraid. It's got to be an impossibility. Not that you're afraid of settling, or if settlement can be done in a different way. Okay, so it's not a get out of jail free card, and that's what she's trying to use it as. And I would agree, and I'd have an attorney draft some kind of a letter to them and say,
to the title company or to the brokerage?
I would.
The title company is holding up the EMD, RGS.
Well, if you want to go after the EMD, RGS will not release it unless somebody signed an agreement. So at this point, I probably would have some kind of an attorney draft up a letter saying, you know, in our opinion, you are in default, and you know, this was not an impossibility to settle. It's not a get out of jail free clause.
Okay. All right. So, and the second question relies to as on the buyer side. So the buyer, okay, but before we go on, besides the $10,000, can we go after anything else? Because
Why?
my seller is actually using this money to buy another house.
Yeah, but you know, if you try to go after anything else, you're going to be in a lawsuit for quite some time.
Okay.
What price is the house?
The condo was sales price was $240, cash deal, no contingencies, and it was 10,000 EMD, and that's it pretty much.
Okay, so the board put out the attorney at the NVAR put out an explanation of the addendum, and let me read to you from his explanation. Unforeseeable event includes any event or circumstances beyond a party's reasonable control that causes performances to become impossible or impracticable. Impossibility does not mean subjective fear, difficulty, or inconvenience. If parties can perform by any other means, the addendum will not excuse performance. Okay, so the subjective fear is not a reason to get out.
On the same side, on the seller side now, this is the buyer. They had a builder contract. They are supposed to settle on May 7th, and she can't find movers and all, so she wants to delay it by like 15 days or 20 days.
Well, I would go to them and then negotiate. They will probably negotiate with you, but you can draft up an addendum prior to ratification of a contract, or this addendum at NVAR allows changes to a contractual agreement afterwards by specific paragraphs. But if it was a builder, it's probably their own contract.
Right.
So I would call them and see if I
But
can
I mean,
negotiate.
on the human factor, I said, since they're a big builder, they'll say, yeah, you can delay it by 10 days or not. I mean, in your opinion?
I think they would probably give it to you. They don't want to lose a contract.
Okay. Thank you, Larry. Thanks for answering the questions.
All right. Any other questions? Let's take a look at the COVID-19 addendum form. Okay. First question, do you have to use an addendum? No. Okay. But if you don't use the addendum and you try to use common law and you already know the pandemic is out there, then you're probably asking for a problem. So use the addendum before you enter into a contract so that it does, if it is an impossibility, say we're all quarantined and can't do a settlement. Well, this is not going to, first of all, I want you to understand, there's nothing even in this COVID addendum that will give you the opportunity to void a contract. Okay? There's nothing anywhere in our contract, even with the addendum, that will allow you to void. What happens is, if we get to the settlement date, midnight, your contract no longer exists, then they're saying that there would not be a default. Therefore, the person would be out of the contract. But it's not a void contract up front because you just went out of the contract. Okay? Unless all parties agree in writing that we're not going to have a contract anymore, at any time you could go ahead and sign a release and move forward. Okay, so let's just go through this contract addendum form, take a look at it, and answer questions and do a little explanation of it. Buyer and seller acknowledge that COVID-19 pandemic may have unforeseeable and indefinite impacts on real estate transactions. Well, the one that we're hearing, and I'm hearing a lot of complaints, not only from our company, but others, what about the appraisal? And what about appraisers getting in there? And if you're an appraiser, you're going out to appraise a property, what do you think is going to happen to property values because of this? I'd be a little concerned that, hey, property values are what? Possibly going to decrease. So they may even take that in, because I'm hearing that a lot of appraisals come back lower, and the appraisers are saying, we're worried about what? COVID. So be prepared for that. Even getting the appraiser in there, right? This addendum is designed to protect parties from default, okay, in the event that they are unable to perform due to circumstances beyond their control. Once again, that is not because they have become what? Afraid, okay? Or because it's going to be difficult or inconvenient. They may have to go to different places to do this, might have to do it online. And for people like me and my age, it's a challenge when you have to go do stuff online. I prefer face-to-face, but I've had to make the adjustment. I'll be teaching NVAR's continuing ed, same way we're doing it here, just a different method of delivering. So we're going to have to make some changes. So the addendum can be used to extend deadlines and settlement dates as many times as everybody agrees. But do not try to use this COVID addendum with a lease. This is only for the sales contract. Okay? And this addendum, if you look at it, this addendum may be used during or after contract ratification, but it is an addendum. What does that mean? All parties have to agree to it. Okay, so if you have an existing contract and you want to make adjustments, the seller doesn't have to agree to it. If you're using this form afterwards, it'd be nice if they do, but they don't have to agree to it. It is an addendum. Okay. Beforehand, I don't think it's much of a problem as trying to go back later and trying to get people to adjust unless they, being very reasonable. Okay. You can extend these dates as many times as the parties mutually agree, and nothing in this addendum prohibits the parties from agreeing in writing to execute a release under the terms acceptable to both parties. So in the instance where the person's already defaulted, you no longer have a contract, would have to be re-executed to go to settlement, but maybe they, if they hear from an attorney, they might change their mind because it didn't give them the right to do that. Unforeseeable event means any event. And remember, this is in quotation marks. So with our contract, that makes this a definition. Means any event or circumstance beyond a party's reasonable control that causes performance to become impossible or impracticable, including but not limited to epidemics, quarantines, governmental declarations of emergency, closings, or delays. But once again, this is not a get out of jail free card. This is if it was impossible, no way that you could get to the settlement. There are ways that this is happening and taking place. Okay. No default. Once again, once we get to that settlement date, if the buyer had not settled, it would have been a default. This addendum makes it not a default, and there's no liability to the other party for any losses or damages of any nature for any failure to delay in the performance of their obligation under this contract, arising out of or caused by, directly or indirectly, an unforeseeable event. Such obligations under this contract include, but are not limited to, performance, settlement, or delivery of possession of the property. But that is not that get out of jail free card. It does not introduce new contingencies into a contract that weren't there before. And it doesn't bring back, if you've already satisfied a contingency, this does not bring those contingencies back into play. So one of my concerns of people now going out to buy a house, and a friend of mine, Mickey Glassman, was talking about she just had 4 contracts on a house in 2 days, and people really haven't even seen it. And the people are getting in a bidding war, and they are removing contingencies, and that's kind of dangerous because once you remove the contingencies, you can't bring them back with an addendum. So if you're waiving financing or you're waiving home inspections or any of that, this form does not bring those back into play. Okay. People might even be not using this COVID addendum form because it's a multi-contract presentation. Once again, I think that would be pretty dangerous. When we look at paragraph 3 and 4, this is when you use it for an existing contract. Okay. General statement, settlement date and deadline. This one, number 3, extends all deadlines, not specific. Okay. Extended by X number of days. If no agreement, then the contract still ends at settlement date at At that point, you would no longer have a contract if you did not settle, and you would be in default. Okay? Specific extensions. So paragraph 4 is when we actually use this to do specific extensions. You could just choose settlement date, home inspection, whichever one you need, but once again, does not bring back into effect anything you've already removed. So that's the NVAR addendum form. Any questions about the form itself?
Yeah, Larry, I do have one. This is new again. On that general settlement date and deadline extension, if we had put 15 days for sellers and buyers, so that means only the settlement date can be extended one time for 15 days or indefinitely for 15 days?
No, it's extended one time for 15 days. If you need another one, you see up at the top of the form where it says number on the very top of the form. So say you extended it one time for 15 days, and that was number 1. If you needed an additional 15 days, you would have another one of these number 2.
Right.
Okay. So you could continue to extend with these as many times as you need.
Okay.
What if you said 7 days, and then number 1 said 7 and number 2 said 15? Well, that's 22 days. So if you did 7 and you realized that wasn't going to be enough, you're in the 3rd day, you still have those 4 plus the additional 15 because you had multiple addendums.
All right, sounds good. Thank you.
Okay. Now, what about homeowners docs? I know people have been having trouble getting homeowners docs. Can this COVID addendum form extend the time period for homeowners docs? No. Our statute is firm. It's 3 days from the date that you receive the documents or the notice that they would not be available. So if you get a written notice that they're not going to be available because of this COVID-19, your buyer now has 3 days to void the contract. Okay? So those dates, that's not a date that can be extended. Beginning July 1st, the law will allow a 7-day extension on top of the 3, but that's only if everybody agrees in writing, and that doesn't go into effect until July 1st, and that's if the governor signs it. So this does not extend any time periods for documents. I got a question yesterday about when it comes to these documents, it's not really, I mean, it's a homeowners association, but it's not really. They collect money and they don't enforce anything. Do we still have to receive the documents? Yes. I mean, unless you received a notice that there are no documents, which they probably could send, then you have the 3 days. So you can always go to the Common Interest Community Board, check to see if the documents have been filed. They have to file reports every year with the CIC or the SCC in Virginia. So if they filed reports, make sure you get the documents or notice of non-availability. Any other questions about it? And also the use of this COVID addendum, it does not extend any or change any other provisions in the contract. It only modifies those expressly referenced and agreed to by the parties, and that's under specific extensions. Anything else? Any questions about anything else?
Well, before you finish, Larry, if I can just remind my agents, the ones from Tyson's and Herndon, please, if you don't settle with Realty Title of Tyson's, make sure that you ask the title company to send a wire to Fairfax Realty. You have to call Jocelyn at 703-752-8660 to get all the information about the wire. Please do not come to the office with checks. You need to have the other title company send us a wire. And if you're going to do a lease and you want to get paid, I need to have all the documents. And if it is a contract, please make sure that the earnest money deposit goes to Realty Title by wire. There is no need to come to the office. Jocelyn is not depositing checks. I have sent probably 15 emails and I keep still getting checks into the office. So please, it's for your own sake, it's for your own health and for your own protection, and also for Jocelyn's protection. I'm not at the office, but I am available all the time on the phone.
Okay. I want to real briefly touch on the financing and appraisal contingencies addendums, just the conventional one. If you're not aware, they did make a change to the conventional appraisal contingency addendum where there's a paragraph 3, financing with an automatic extension, and a paragraph 4, financing contingency with automatic expiration. So the paragraph 3 on the conventional financing addendum is what we've had all along. You have X number of days to send us over the written conditional commitment. If you don't, and use paragraph 3, it will continue on until settlement date, not settlement, settlement date. So up until that time, the purchaser could get denied and they're out. But if you're using paragraph 4, which is really kind of dangerous now, especially with this pandemic, because you want to get your contract through, that is automatic expiration. When you reach that 21 days or whatever you put in that paragraph, at that point, if your buyer hasn't been turned down for their mortgage, there is no financing contingency. Okay, so be careful how you use paragraph 3 and paragraph 4. We'll address that more when we do our next session. And Johanna, the next session, I'd like us to go over the changes to the forms that we have and changes to laws coming up. Maybe we'll do that next week one day.
Yeah, probably next Friday, or do you rather have it Wednesday?
Wednesday or Friday's fine, just not Tuesday and Thursday. That's my golf days.
Okay, we'll send
Emmett?
emails.
Emmett, we don't give up golf days, do we?
No, I'm very happy that even though it was short term, with so many emails that were sent, we have 31 participants. So that's a good number, you know, for a short time notice. So let's do it next Friday so I have enough time to send the emails.
Okay, and I mean, if the other offices want something like this, we can do that also, Emmett, if you want to set it up there. I know.
Well, what happens is that everything is going to go to all the offices. Right now, we're going to be sharing. This that you're doing goes to Falls Church, 5066, Herndon, and Tyson's. We're all going to be sharing all this, and then it's going to go into YouTube.
Okay. So you will put out where they can access YouTube?
Yeah, sure.
Okay. Good. Any other questions about anything?
Yeah, Larry. So one more question, not in reference to COVID, but overall, when we put like a 3-day, the selling agent will deposit such and such amount of money in 3 days. What if they don't do it in 3 days? What happens? Kind of.
So if the deposit isn't made within the 3 days, okay, then so what you're using is a clause in the contract that says they will bring the check within 3 days. They didn't have it when they did it, or just not deposit it.
Well, basically, it says that it will be delivered to the escrow agent, which is RGS Title, within 3 days.
Okay, so if it hasn't been delivered, then and you're representing the buyer, then you would notify the other side that the check has not been delivered. Okay, but if so you do have to notify them that the check has not been delivered. It doesn't constitute a default, but it does constitute a breach of the contract, which so needs to be taken care of.
if they do, let's say in 7 days or 9 days or 3 days, is it a real negligence or is it not? I mean,
Well, it's a, at that point, it's a breach of contract. I mean, breach of contract term between a buyer and a seller. It's not the duty, it's not anything the agent did wrong, but the agent needs to keep everybody informed of anything that affects the contract. So, the negligence would be if you didn't tell, in my opinion.
gotcha.
Larry, I have a question. This is Clody. When you were
Yes.
talking about the renters, and you said something about for rent reductions, did you say the forms were on VAR or NVAR?
The VAR, Virginia
Okay.
Association of Realtors.
Okay, thank you.
And it's their form 200. What I'll do is get this to, just have Jocelyn pull them, and then, or you can go and download them. But they're pretty good forms. I like them, where the tenant actually submits the reason and showing proof that, not just say, hey, it didn't happen.
Okay, great. Thank you.
Yeah.
Larry, I think that Dean Pham had a question for you. He typed it. I don't know whether he has spoken to you.
I see his hand raised here, but I have no way of seeing. Wait a minute, I brought his raised hand up, but I don't see anything.
It says, what if
What
the
if the
buyer
buyer-
waives?
Okay. What if the buyer waives financing contingency? What about it? If they've waived, because if they've waived their financing contingency, then the COVID-19 addendum would not come into play, because you can't, it doesn't bring other clauses back into play that didn't exist in the beginning. Anything that's been satisfied already, or anything that's been removed, that doesn't add it back to the contract. So if somebody tried to use paragraph 4 on this addendum form and check financing deadline after they'd already removed the financing, that would not.
Hi, Larry, what's the time frame for closings now? Is it the same? I asked for at least a month, but listing thought it was too much. What do you recommend? Is the agent allowed to go to closing now? How about the home inspections?
I still use 45 days, but it's a matter of negotiation. But how are you going to get there with the way things are slowed down? Now, how are you going to get there in 30 days? Unless you're using an addendum that will, allow for extensions, because come midnight of the day of settlement, your buyer would be in default if they're not ready to go. So I'd go over it with my client to make sure they understood the risk they're taking. The fact that your lender can't work fast enough, or the appraiser's fast enough because of this pandemic, I don't think it's going to get them out of the contract.
And then the other thing she's asking is the agent allowed to go to closings and home inspections?
Yes. But if you go to closing, there's going to be 6-foot spacing. So they may be out the door. And that's going to be, that's going to really be up to the settlement company, how they handle the spacing. But I think you have the right to be at the table.
And what about the home inspection? Can you send the inspector alone? I guess that's your question.
No.
No?
I mean, if the owner will allow it, yes, but get that in writing from the owner and from your buyer client, because the law says they can't be in a property unattended. So they can't be there by themselves. Somebody's got to be there with them.
Sully, is that all you had of questions?
She said, thanks.
Okay.
And I'll have to find that where I read all those questions for the next time. Let's see. Okay. I appreciate all the people that are actually on screen so I can see you. It's nice to see you guys.
And Larry, on the continuing education, are you going to do through Zoom also?
I am going to do continuing ed for NVAR, but they use GoToMeeting, I think.
Okay, okay.
So you can sign up for that. We're going to do it in 4-hour sessions next Friday and Saturday, and then probably the following Friday and Saturday for the 16 hours. Hopefully this will be over by May, where we can get back in a classroom, but if not, this is the way we'll be communicating.
Larry, are you doing any Maryland classes or just Virginia classes?
Just Virginia.
Okay.
Yeah, I gave up my Maryland license and DC licenses. I only have Florida and Virginia now.
Okay, good old
But just
Florida.
for your information, we're trying to get a seminar of the Maryland contract, and we'll let everybody know. We're trying to coordinate everything with Dave so that all the 4 offices, but in this also the Maryland offices will be involved.
Great, thank you.
Okay, anybody else? I think this worked out pretty well for our first shot.